Subramanian Swamy and Dr. Venkat Iyer, who's a barrister based in Belfast. He keeps in touch. He's basically a lawyer, educated and born and brought up in India, and now he is settled abroad. But he is in constant touch, visiting our country and many universities and media advisors and discussing media laws and various aspects of law. And he's available to our Virat Hindustan Sangam to educate and empower, as our motto goes, the people on the various aspects which a common man needs to understand. Today is our third lecture in this series of Legal Gyan Ganga, or as we call Nyay Gyan Ganga, or Legal Words of Wisdom. Today's lecture, we are going to be devoting to how are disputes resolved. In one method of dispute resolution better than the another. What should you know if you are planning to sue somebody? How can you maximize your chances in litigation? What are the common pitfalls that should be avoided when dealing with the law and lawyers? These are some of the questions that will be discussed in today's episode. And as I mentioned, Dr. Venkat Iyer is in touch with lot of institutions in India, educating the judges, the legal fraternity. He's been associated with various international organizations. So we thank Dr. Venkat Iyer and Dr. Swamy for being on our show. So with these opening remarks, it is over to Dr. Swamy to start the program and take it forward. Then Dr. Venkat Iyer will start speaking on the subject today. Over to Dr. Swamy.
Uh, Thank you, Jagdish. But of course, today I'll be a listener because this is a topic which I have barely touched in my entire dealing with law courts and legal cases. But is a very important aspect of law. In fact, that's, in my opinion, a preferred method of conciliation. Dispute resolution, as the topic is given, can be done in a number of ways. Even when you file a case in the court and then you're the plaintiff and the other is the defendant, and the court then resolves the dispute because what the plaintiff says is disputed by the defendant and vice versa. And so the court ultimately has to resolve it, and both have to accept that unless they want to appeal to a higher court, and where the same thing happens. Then there is the concept of arbitration, and where you appoint a arbitrator, and then he listens to both, and then it's in another form of a court, but it's much more informal, and all the technicalities of law and the how you argue in court and all that is not there. The formality of the court is not there. Then there's mediation, conciliation, negotiation, and facilitation. So, of course, Venkat has been an expert, and so these are my layman, so to speak, classification. And of course, he can tell us what's a better way to look at the dispute resolution procedures and the mechanics of it. And so we are all going to listen fully to Dr. Venkat, and then towards the end, maybe if there is anything for me to say, I'll make a concluding remarks before we go out of this program. Thank you very much to both Jagdish and Ramesh and all the other people behind the scenes who have managed to bring us from 2 cities of India and 1 city of Ireland. And so we are able to address and inform our people who are all over the world listening to this program. Over to you, Dr. Venkat.
Thank you, Swamy. As has already been flagged, I plan to talk about dispute resolution and some practical issues concerning that topic. The aim is to give you an idea of what the options open to you are if you find yourself with a dispute on your hands. I know that it can be quite stressful when that happens. It can also leave you confused. I'm going to address the topic purely from a layperson's point of view and not from a legal practitioner's or an academic lawyer's perspective. For as long as humans have lived alongside each other in a community or in a society, disputes have arisen, and so has the need to resolve them. We can classify methods through which disputes are resolved into three broad groups. First of all, you have adjudicative processes in which a neutral third party, such as a judge or an arbitrator, determines the rights and wrongs of a dispute. And typical examples in this category of dispute resolution would be litigation or arbitration. Then you have consensual processes in which the parties come together, usually with the aid of neutral facilitators, and try to reach an agreed solution to the problems that lie beneath the dispute. And typical examples of this category of dispute resolution would include mediation, conciliation, or negotiation. And thirdly, you have coercive processes in which the parties are compelled on pain of some coercive action, such as violence or duress or threat of force, to agree to an end to the dispute. And typical examples under this category of dispute resolution would include vigilantism, bullying, gangsterism, etc. It goes without saying that only the first two processes are legal, and the third would be not only illegal, but totally unacceptable in any society which aspires to be called civilized and which believes in the rule of law. And yet, it is a sad reality of the world in which we live that coercive processes are not uncommon in many countries and also in many communities. It is usually the result of mainstream legal processes of dispute resolution breaking down and public confidence in those processes disappearing altogether. Let me give you a scenario which will help you understand this phenomenon better. Let's assume that you live in a country which has a glorious history and a carefully constructed legal system, like India. Let's assume also that over time, as a result of various factors, including political mismanagement, growing corruption, stepmotherly treatment of the judiciary by the government, plummeting standards of legal education and training, and so on, cases begin to take up to 30 years to be heard and disposed of in the first instance. Let's assume further that lawyers in this country start exploiting this unsatisfactory state of affairs and not only charge exorbitant and often extortionate fees, but also treat their own clients with disdain and contempt and behave in the most unprofessional manner. Against this backdrop, let's assume that you have a dispute with your neighbor who has encroached on your land and whose bullying behavior has made your life miserable. You know that the law is on your side. You also know that any reasonable judge will rule in your favor and against your neighbor when he has had an opportunity to hear and understand the evidence that you have in your possession. But you don't get a hearing because the courts are clogged. Now, against this background, someone introduces you to a friendly local neighborhood gangster who, after listening to your woes, tells you that he'll be able to put you out of your misery in just a few days' time and at an affordable cost, certainly at a cost which is much smaller than the substantial amounts you have already spent on your lawyer, who's been asking you for money each time the case is adjourned. Would you not be tempted to avail of the services of the gangster? Most decent people will have serious qualms about going down that route, but so stark are the choices that principles may not sometimes stand a chance against pragmatism. Now, don't get me wrong, I'm not saying that the dispute resolution process offered by the gangster should be preferred to relying on the courts. But if a system begins to rot in the way that I've described, it would be a huge wonder if anybody retains any faith in the rule of law. Now, why have I given you this apocalyptic vision? Just to underline that easy and timely enforcement of the law is just as important as the quality or the fairness of the law itself. It is my considered belief that the law enforcement system in India has in recent years begun to present problems of such magnitude that it is deeply disturbing to most right thinking people. I do not, alas, have the time to offer you a detailed analysis of how things have come to such a pass, but I want to suggest that even at this late stage, there are certain things that can be done to save the system from total collapse. More importantly, I want to say that there are certain options which can be used to overcome the problem caused by law's interminable delays when it comes to dispute resolution. The first substantial point I would make is that mediation has not been given the importance that it deserves in India. There are few countries where mediation cries out to be embraced with open arms as India. And I'm not talking only about organized mediation that is sometimes spoken about fashionably, but also about traditional forms of mediation conducted, for example, by family elders, leaders of community organizations, village councils, and so on. There is a lot of misunderstanding about mediation. It is not, as is sometimes lazily assumed, a system under which people simply agree to split their differences. That may happen, but it is more likely that certain other creative solutions are adopted, which can leave everyone involved in a dispute more satisfied than they would be in a combative process like litigation. For a start, mediation is informal and more collaborative. It is conducted in surroundings which are less stressful than a courtroom or an arbitration chamber. It is consensual, which means that the parties have more control over the process. Among other things, they can choose as the mediator someone they are comfortable with. And unlike a judge or an arbitrator, the mediator is not bound by rigid procedural rules and can suggest novel and context appropriate solutions. No party needs to agree to an outcome that he or she is not happy with. Very importantly, if no solution emerges at the end of the mediation process, then other avenues such as arbitration or litigation are still open. Mediation can also be cost effective, partly because there's no need for lawyers to be engaged. Anyone can mediate and anyone can be hired to assist the parties, partly because there are no elaborate rules of evidence and therefore no need for expensive paperwork and documentation, and partly because most mediations can be carried out on a fixed fee agreed in advance and usually on the understanding that the fee will be borne equally by the parties regardless of the outcome. So, anyone looking objectively at the situation in India cannot but be astounded and appalled by the cold reception which is given to mediation by lawyers. And I should add, also by warring parties. The reasons are not difficult to understand. Litigation, as it is conducted in India, is a bonanza for everyone except the honest litigant. There are just too many vested interests who profit from the enormous delays in the law, the foremost of whom is the dishonest or the recalcitrant party to a dispute. Why should someone who knows that he's in the wrong, but who also knows that as long as he can play the rotten justice system with the help of greedy and unethical lawyers and drag a lawsuit for 20 or 30 years, want to see the end of the case quickly? There is another reason why this rot is allowed to continue. It is that there are no sanctions applied in India against unmeritorious and dishonest litigants. In most decent countries, if someone brings a frivolous or vexatious case against another person and the case is thrown out, or it is discovered early enough that there is no merit in the case, the party bringing the case is made to pay heavy costs to the other side. Not so in India. In the absence of a financial disincentive or a deterrent, people are emboldened to sue without any sense of responsibility. You don't need to be a genius to work out that probably two-thirds of all cases pending before the Indian courts will disappear without a trace, simply by judges taking a tough stand on costs, which the law incidentally allows them to do, or judges compelling litigants to try mediation first on pain of financial sanctions if they fail to comply. I accept that mediation may not work in all cases. It is certainly not suitable, for example, in criminal cases. And it's also possible that some genuine attempts at mediation may fail. In that case, litigation becomes inevitable. And I will now deal with some aspects of what a person can do when he or she is faced with the inevitability of litigation, either as a plaintiff or as a defendant. I'm not going to deal with arbitration at any length, only because it's a subject which deserves to be given extensive treatment, for which I do not have the time today. But I hope to be able to return to that subject in a later lecture. The first point I would make about litigation is that you should not resort to it lightly or unthinkingly. There are many considerations that go into the decision of whether to sue or not. Tactics are as important as strategy. Also, it's very common for people to be convinced in their own minds that they have the right, they have right on their side, and therefore a strong belief that they will win a case. But they don't often realize that, however right they may be, they may not have the evidence that is needed to succeed in a law court. I accept that this is unfortunate and that it can lead to injustice. But the reality is that for certain widely accepted reasons, every legal system has to have rules of evidence and rules of procedure which cannot be dispensed with. Therefore, I would say that before you think of suing someone, please make sure that you have the evidence that the law will require you to produce if you are to succeed. And always collect and secure your evidence before you launch legal proceedings, not after. It is not uncommon for litigants to be tripped up because they've been told by someone that the evidence will be forthcoming, but that person then takes fright and disappears once a suit has been filed. And this happens especially in defamation cases. If you don't have the evidence or cannot obtain it, it is much better to seek a compromise with the other side in conditions in which you can cut your losses and retain your dignity. It is also important in litigation to know your opponent. In particular, you should make an informed guess about how likely it is that the opponent will mount up a strong and credible defense. No less importantly, you'll have to be satisfied that even if you win the case, the other side will be able to satisfy any judgment, especially monetary judgment, that the court will pass. Otherwise, you'll end up with what is called a Pyrrhic victory. Another calculation you'll have to make is whether you have the staying power for the fight. This includes not only the financial resources, which can be substantial, but also the patience and the stamina to sustain the fight to its logical end, which can usually be in India many years ahead. There is no point in starting a suit and discovering midway that you've run out of money or energy to keep it going. A very important decision you need to make when litigating is, first of all, whether you need to employ a lawyer. You may be surprised to hear that many cases are simple enough with a little bit of study and preparation to be fought without a lawyer. Swamy has, of course, spoken about this matter at length, and he has also shown by personal example how even seemingly formidable cases can be litigated on one's own. Unfortunately, legal processes in India are still too complex and too bewildering for most lay people to take up the challenge. Also, as far as I know, judges in India do not show the same willingness to be indulgent towards litigants in person that I've seen them do in other jurisdictions, including the UK. If you do have to engage a lawyer, you need to think carefully about that choice. The sad reality is that there are far too many substandard lawyers, and sadder still, there is a massive lack of professionalism among many Indian lawyers. It is not uncommon for a lawyer not to show up at hearings or to come unprepared. I've also heard horror stories of lawyers colluding with their opponents to the detriment of their own clients. Furthermore, the system allows lawyers to get away with extortionate fees and to string cases along needlessly for their own benefit. Part of the problem is the absence of professional ethics, which in other countries is given great importance in the training of lawyers, and part of it is lax regulation of the profession. The entire legal profession in India has become one massive closed shop. You will have heard about the tremendous resistance that comes up whenever there's any suggestion for opening up the legal profession to practitioners from outside. What this means in practice is that competition is stifled, especially at the higher end of the legal market, and Indian litigants are left with no choice except to rely on a small pool of complacent and, I would say, ethically challenged local lawyers. Which is not to say that there are no talented or honest lawyers in India. Don't get me wrong. There are quite a few of those around as well. But given the size of the Indian market, it'll not be easy to locate them. So you'll need to consult widely before you choose your lawyer. As a general rule, avoid the flashy types, the ones who either show a propensity for self advertisement or who make extravagant promises about what they can deliver. Be particularly wary of those lawyers who appear frequently on television or feature on the social pages of newspapers. These are usually pushy types whose bluster and smooth talk conceals a shallowness which can prove harmful to your interests. By contrast, you may find a relatively low key, self effacing lawyer who delivers the goods conscientiously, and you should not hesitate in engaging such a person. Try as hard as you can to agree the lawyer's fees in advance. It is true that litigation costs are unpredictable, especially in India, where cases get adjourned repeatedly. But even so, avoid a situation where the lawyer is given an opportunity to argue that you had left the basis of the engagement so vague that he is justified in making unreasonable demands. It's always a good idea to record the terms of engagement fully and clearly, even if that is done relatively informally, say in an email exchange. In the choice of lawyer, it would help if you went by recommendations from people you can trust and people who know the lawyer being recommended. Another advantage of doing that is that should a dispute arise in the course of your dealings with the lawyer, then the referrer can be asked to assist in resolving the dispute. Peer pressure is very often more effective in such circumstances than resort to formal complaints procedures, which are anyway very weak in India. Now, for those of you who may not be able to afford the costs of litigation, the good news is that there are still a number of lawyers who are willing to take up cases without any expectation of monetary reward. These are called pro bono lawyers, and some of them can be located through word of mouth. But there are also formal legal aid centers attached to most courts where you can find them. Despite everything I've said about the low level of professional ethics in the Indian legal profession, I have to also say that quite a few senior lawyers, too, including some well known ones, do pro bono work. The challenge often is to A, make contact with them, and B, persuade them to take up your case. But you need to remember that getting a pro bono lawyer does not mean that you don't have to spend anything on the litigation. Unfortunately, there are what are called costs to be met, and these include court fees, expenses on photocopying, postage, travel, etc. And they can all add up to a substantial sum. Before I leave the topic of litigation behind, I want to address a couple of other important issues. First, you need to think carefully about remedies. That is, what you want tangibly out of the litigation. Most of the time, it'll be monetary compensation, for which the technical word is damages, or a return of property or an order quashing a decision that's been passed against you. But sometimes you would do well to ask for other remedies, such as a declaration or an injunction or a stay order or a decree for specific performance. Given the frustrating delays in the Indian legal system, very often a temporary remedy, like an injunction or a stay order, may be half the battle won. It means, for example, that the other side will come to you seeking a settlement because they don't want to suffer the consequences of an injunction or a stay order for decades on end. In certain types of contractual disputes, it might be preferable to ask for an order requiring the other side to do something they've promised but failed to do, for example, delivering possession of a flat, rather than asking for monetary compensation for the failure. When you do this, you're asking for what is called a decree of specific performance. You'll have to give very careful thought before you file a case to this aspect of the matter. And sometimes you'll have to impress upon your own lawyer what is more important to you, because he or she may not quite appreciate your priorities or your preferences. Don't hesitate to be forceful with your own lawyer if need be. The second thing I want to say is if you lose a case, you'll need to consider carefully whether you want to go in appeal. Almost every court order allows for an appeal to be filed in a higher court. But filing an appeal is not a mechanical exercise, and it requires many factors to be weighed in the balance. Clearly, the strength of your case is important, but so is the question of whether, however strong your case may be on the merits or in fairness, there are procedural hurdles that you may find difficult to overcome. Also relevant will be how the trial court has assessed the strength of your case. Generally speaking, a higher court will not easily or lightly overturn a lower court's verdict. But if there's any perversity or lacuna in the lower court's assessment, then you stand a good chance of having it set aside. Remember that appeals are also costly. They can be time consuming, they can be stressful. So, you need to think hard before you go in for an appeal. Sometimes you'll be required to defend an appeal, and that is because you won the case in the lower court, but the other side has decided to take it to a higher court. Again, you'll have to pay much attention, especially when it comes to stopping the other side from obtaining a stay order against the lower court's verdict and leaving you high and dry despite your victory there. One other word in relation to litigation. Try, if you can, to have some hold over your opponent before you launch your case. In commercial matters, this will mean, for example, asking the court for an order that the opponent should deposit a sum of money to ensure that if you win the case, you're not left facing the prospect of the opponent denying you the fruits of your victory. Actually, you should provide for such contingencies even before the dispute arises, by, for example, concluding contracts that incorporate a clause for a bank guarantee. There's much more that can be said on this topic, but alas, I think, running out of time. Before I conclude, I just want to spend a minute or two referring to arbitration as a method of dispute resolution. In principle, it's a good way of resolving disputes because, among other things, it is, if conducted properly, less formal than litigation, has the potential to be cheaper, allows for greater privacy for the parties, and is capable of producing results quicker. Unfortunately, the record of arbitrations in India is less than glorious. And this is because, A, it's not given the finality that it is intended to be given, with the result that a lot of arbitrations are followed by further rounds of litigation, which happens typically in the courts, much to the delight of lawyers. B, the enforcement of arbitral awards in India is not straightforward, easy, or smooth. C, arbitration is just as expensive as litigation, given the stranglehold that lawyers have on the arbitration market. And D, there are very few effective controls over misconduct in arbitrations. If you're a commercial entity, especially a foreign commercial entity, you will be persuaded very strongly by your own lawyer in India to insert an arbitration clause in agreements that you'll be signing with other commercial entities, something which is routine in global business. But I would ask you to be careful, and I would strike a note of caution because there is a risk when you do that. That blandishment may not always be the best course of action for you. You should also, especially if you're a foreign party, build in other hard-headed practical safeguards to protect your interests in commercial transactions with Indian entities. If there's any interest in that topic, I'm happy to address it at length in a later lecture. That, I'm afraid, brings us to the end of this session. As always, the clock has beaten us, and I don't want to overstay my welcome. I hope you'll keep your comments and suggestions coming. Thank you very much.
Dr. Swamy, your comments. He's muted. 1 minute.
Studied law.
Dr. Swamy, 1 minute. There is some audio problem.
Yeah, go ahead, Dr. Swamy.
And start from the beginning.
Okay, I said after hearing you, Dr. Venkat, I, as a politician who was trained as an economist and has learned law on his own, I feel now I've made a mistake in not spending some time on arbitration and reconciliation, because I'm, as a politician, I'm all the time being asked to do it for petty matters. But now I think it is a much bigger subject, and certainly one of the consequences of your lecture would be that I might start paying attention on these matters of arbitration and so on, so that the load on the courts also can go down. One short question. You spoke about the lack of much scope in criminal law for arbitration. How would you place plea bargaining in this context?
Okay. Actually, I said there's not much scope for mediation in criminal law, not arbitration, because arbitration is like litigation. Yep. So, well, yeah. Okay. Anyway, it doesn't affect right. the merit of your question. Now, plea bargaining actually has got, in some quarters, not a very good reputation, because the argument against plea bargaining is this, that you're, in a sense, diluting the nature of the offense or the seriousness of the offense. In other words, what you're saying is, from the victim's point of view, you're not giving the offender the full treatment of the law that he or she expects. But on the other hand, if you look at the situation in a country like India, where the courts are clogged, then if you had a lot of cases, criminal cases, where decent plea bargaining, that is to say, where one side just doesn't buckle completely, or when the offender is not treated too lightly, then I think there is a lot to be said for plea bargaining. But it all depends on how carefully the process is structured, because plea bargaining is not a straightforward case of somebody saying, look, the prosecutor saying, look, you would have got 10 years jail if the case was allowed to proceed. I'm willing to allow you to go scot free with 3 years jail. Now, that is not the kind of negotiation which happens in practice or should happen in practice. There has to be a clear recognition, first of all, on the part of the offender that he has done something wrong. He is not getting away lightly simply because the system is broken. So there are issues like that. And secondly, also, it is possible to build into plea bargaining certain other additional features which will make the victim of the crime less unhappy than he would be if the plea bargaining went on straight lines of whether it's 5 years for 10 years. So I would give it a cautious welcome. I wouldn't dismiss it out of hand.
Jagdish and Ramesh.
Yeah, Jagdish, you go first.
No, I have a question to Dr. Venkat. In fact, many of the viewers, which you have touched upon it, they feel that litigation is a time-consuming and costly affair. Why should even we resort to this type of things? Because they feel that from many of the comments which we have received, they feel that this is a very expensive and expensive both time-wise and money-wise. So why we should resort to it, although it is becoming impossible not to resort, but philosophically they want to know whether there is any ground in just keep on fighting when cases in the trial courts, civil side especially, sometimes goes on for 30 or 40 years to they have given examples of numerous cases. So just it's a comment, I just wanted to bring it to your notice, because generally when we speak about law in India, as you already touched on the subject, people are just fed up on the delays, and they feel that our system is not well equipped. So just wanted a comment from you and perhaps Dr. Swamy also.
Okay, well, as you must have gathered from the tone and tenor of my remarks, I'm not a fanatic for litigation, quite the opposite. And actually, in Indian legal circles, I'm quite unpopular for espousing that view. Um, Many of my friends, extremely distinguished lawyers and very wealthy lawyers, are extremely upset when I say this. So my view is litigation sometimes is unavoidable, and in those circumstances, you can't rule it out. But my own view is that mediation is probably best suited for India, given all the factors, including a number of cultural factors, which I've not had the time to talk about. But mediation is helpful, and I think someone like Swamy, for example, would be a very good mediator, not necessarily in commercial disputes, but all kinds of disputes. And mediation actually has had a good track record in India over the years, not in recent years, but let's say going back a few decades. Now, litigation is not something that can be completely avoided, and therefore you have to have the courts. And again, if you look at some of the experiences of litigation in the Bombay High Court, there used to be a judge called Pense, M.L. Pense, who, in spite of all the chaos and the problems that existed, was able to deal with cases very quickly. Now, how did he do it? He did it because he had a sense of, first of all, a sense of purpose, secondly, a sense of justice, and thirdly, a sense of urgency. And he was able, therefore, to be effective in the way that he dealt with cases. And like that, there are other examples in other high courts. It's not impossible. I personally think there are just too many vested interests. And unfortunately, lawyers come pretty top of that list. So quite a few things that we all should think about when it comes to dispute resolution.
Line. in the case of defamation, after I started winning a series of defamation cases, I found that the people started who filed defamation cases against me began to seek a mediation, that they would apologize and whether I would then be satisfied with that. Now, one of the reasons I accepted in many cases just an apology, when I could have got a few crores in the civil defamation cases, and or sent a person to prison in a criminal defamation case, because we have both. And I think in Britain now they've given up criminal. In America, they've never had criminal. And I don't think criminal defamation should be there. I did try to get it struck down, but we had a very timid Chief Justice. He didn't want to go that far. But one day I hope to return to this. But in a criminal defamation case, if I am defamed, I have to file a criminal complaint. And then the first person who is cross-examined is the complainant himself. And a man who has defamed you can then proceed in the cross-examination to defame you even more. See, because and in a criminal law, the accused who's been accused of defamation, he's not cross-examined. So therefore, in a criminal defamation, I have been through one criminal defamation that's been against Jetmanani, won the case. But the fact is that you have to go through a great deal of agony, because all kinds of irrelevant issues are raised, and the judges, especially high-powered individuals who have been in politics, have been ministers, and then he becomes very, lax in giving permission, to allow you to go into all kinds of things. So therefore, I think there should be a compulsory clause in the defamation law that it will be first referred to a mediation board and see whether you can work out a compromise. Because that's beneficial to both, and both would have established. One says, "I'm sorry about it," and the other says, "Okay, I don't want to send you to jail, or I don't want your compensation." In the civil defamation case, both are to be cross-examined, both the plaintiff and the defendant. But I got around it by saying that the plaintiff has proved my case, so therefore I shouldn't be cross-examined. So Jetmanani had filed a number of cases against me, and he always wanted me on the cross-examination box, but he failed, because what I extracted out of him as a plaintiff who was first cross-examined was sufficient to establish my case that what I said in defamation was in fact true. So I didn't have to do it. But there also, you see, you sue somebody, and then you have to pay 10% of that money you claim as a court fee, and then it goes on and on and on, because civil suits take a lot of time. So I'm totally persuaded that as far as things like defamation, we must require that you first go through a mediation process and then be allowed to come to court.
Yeah,
Dr. Swamy, I have a question for you.
Yeah.
For me or him?
No, for you. Since you're talking about defamation, either of you can answer. This is a question.
You should answer first.
Yeah. Is there a statute of limitation, a time limitation for civil defamation?
The short answer
Yes,
is
sir.
yes. Yes, absolutely. And I think that limitation period has to be reduced very significantly. We went through this big change in the UK, and now the limitation period for civil defamation is very strictly 1 year. 1 year from the time the cause of action has arisen, because otherwise it's going to lead to all kinds of completely frivolous cases. Now, I know that defamation, as it happens, is one of the more interesting topics, and I had actually planned to devote 2 programs, one for civil and one for criminal. in the future. So maybe we can actually reserve some of those arguments. And many of the things that Swamy said are so relevant, and there are so many reforms that are needed, not just in criminal law, but also in civil law. So I'm planning actually to bring all this up in the course of 2 dedicated lectures on defamation.
Yeah, this follow-up. I have another. Sorry, go ahead, Dr. Swamy.
No, that's fine. I just said good. That's all.
No, your point. All right. So, do you have anything to add?
No, I think whatever I wanted to ask, I've asked, and I think I'm fully satisfied.
Okay. Yeah, I have one question to Venkat. Where does panchayat come into play? In the sense, like if you go to villages today, even in a lot of the villages in India, I guess, the dispute resolution part, they really don't want to go to court. They'll say, you know what, let's do a panchayat and then try to resolve more, like what Dr. is saying, that, let's just solve it without getting to court. Where does that fall? Is that legally binding?
Well, okay. The short answer to that, again, for reasons of time, is that what happens in a village panchayat is no different from what happens in a mediation. So it has some value. It has what I would call persuasive value, but does not necessarily have legally binding value, except in circumstances where the proceedings are formalized. And I thought actually of dealing with that as well later on, along with one other thing which in India is quite important, and that is lok adalats. So maybe we can have a slightly longer discussion about both of those later on.
Thank you. Thank you, Dr. Venkat, and thank you, Dr. Swamy, for that enlightening episode today of Legal Words of Wisdom, Nyay Gyan Ganga. Today we are completing our 3rd lecture or the 3rd episode of this popular program on Saturday evening, 8 p.m. Indian Standard Time on our Virat Hindustan Sangam channel. We will have another episode, that is the weekly episode of this series, again on the next Saturday, which is the 24th of October at 8 p.m. But we will be having our weekly episode, the Sunday episode, that is tomorrow at 8 p.m. with Dr. Subramanian Swamy on another interesting topic. So with this, we end our today's program. I thank Dr. Venkat Iyer and Dr. Swamy for participating in the program. And I thank my co-host Ramesh Swamy for his help and cooperation in putting this program together. I also wish to thank our technical team led by Ashish Shetty, Tejas Navalgul from Pune, Rakesh Gadgi from Bangalore, Swaminathan from Chennai, Ishwar Iyer from Navi Mumbai, and Mr. Vishal Mehta from Mumbai for their background support for putting many aspects of this program, like designing, graphics, posters, and all these things, and technical support for every week's program and promotional material, and doing a lot of research for this episodes which we beam on Saturdays and Sundays. So with this is Virat Hindustan Sangam thanking our viewers and our members for participating in this program. Thank you, Dhanyavad, and Jai